I saw 4 vehicles. People were brought out of the vehicles. And when I came out of the vehicle, my driver collapsed. I had to drive the vehicle going to Owerri and coming back to Enugu.
Out of fear?
Yeah, out of fear, he collapsed. He passed away. As soon as he saw people with weapons, that was the end of the news. So when I came out of the vehicle, a man walked and looked at me. He said I should come over here. And I followed him. Another person came out. I said, are you Shivdan Olas? I said, yes. He said, God will bless you. I said, why? He said, because we watch you on television. You have been defending our master Nnamdi Kanu. I said, I'll continue to defend him until I die. That he's the summary of all the problems Igbos have in this country. If Nnamdi Kanu is released today, it is more important to me than any Igbo man or anybody being president of Nigeria. Because that boy represents the summary of the oppression, whatever, the shortcomings of our people. A boy who was born only in 1966 took that risk of life to talk for our people. You may not like his methodology, but what he does represents 99% of what Igbos are passing through in this country. But he's in jail. Not many people remember that Nnamdi is in jail. And I pray God that nothing happens to him. Because if anything happens to him, this life, I'll put it on the line again. I pray God that nothing happens to him. So what I'm saying that in that journey, they told me to go that nothing will happen to me. I told them that my driver is already passed away. And they gave me somebody. But I told them, there are a lot of killings going on. They said, oh God, we don't kill anybody. Hausa Fulanis who are killing people. And that is why we are making sure, searching every vehicle to make sure that they don't infiltrate our place, that we don't kill anybody.
Interesting.
And I believe them.
All
so
right.
One of their fellows followed me to Owerri, and I saw what Hope was in, and I came back, dropped him, and went back to Enugu.
And without allowing him to come to court on October 17th for trial, the war was taken to his house in a clear mission to eliminate him. That application was not had until this year May. However, the Nigerian government, of course, moved to Kenya, abducted him in a commando style, kept him somewhere in collaboration apparently with the Kenya authority, kept him in an isolated environment, subjected him to all forms of torture. After spending 8 days, they criminally smuggled him into Nigeria and took him to court on the 29th of June 2021 without reference to us. During that illegal proceedings, he was ordered to be remanded in DSS custody. Also very interesting to note that when he was abducted in Kenya on the 19th of June 2021, 4 days after, or there are a few days after, the prosecution went to court without reference to us also. That was on 23rd of June 2021, and mentioned the case without reference to us. And then we have not been able to establish contact with him. So, unknown to all that were in court, obviously making preparation for him to report to Nigeria. Then on 29th, he took him to court. So when he was abducted in Kenya, because we are using the word abducted, having been confirmed by the court and established before the court that he was actually abducted, the Nigerian government security agent that went to Kenya to pick him never subjected him to any form of preparation proceedings to determine whether or otherwise he has committed offense that will require him to be extradited to Nigeria. These are international instruments which Nigeria is a state party to. They violated this international laws, convention, and protocol in an attempt to forcibly bring it to Nigeria. So, of course, we are aware the position of international laws. And even Nigerian law, which also refers to Section 15 of the Extradition Act, and also OAU Convention and Protocol on Prevention and Combating of Terrorism, and Article 12.4 of African Charter of Human and People's Rights. These are laws Nigeria is a state party to. So we filed an objection before the court. that grounded on so many about 2 grounds. First ground is challenging the powers of the court to proceed with trial without, first of all, determining the manner in which was brought before her court. This fundamental issue was raised. The court the lower court never determined those issues. And the national government never resolved issues with us in that respect. So we went on appeal. An appeal found for us and said that what happened in Kenya is a victim recklessness. And by violating international and local laws, that no trial in Nigeria, no court in Nigeria will ever try Nnamdi again.
All right, Barrister, sorry to interrupt you before you get to the appeal court. I want you to explain to Biafrans what is the meaning of jurisdiction, because people don't understand what jurisdiction is all about. People are saying no.
Okay.
Please go ahead. Explain to them exactly what is jurisdiction.
Now, let me explain it in a layman language.
Thank you very much.
You see, before a court will adjudicate or will handle any matter, the court will determine, first of all, whether the parties are proper before the court, whether the subject matter, the cause of action brought before the court, as such, will the court have powers to adjudicate upon, whether the court is properly constituted to handle that matter, and whether the court has powers. It has powers to look into that matter. If there's any vice of any form which will not permit the court to proceed with the hearing, it will first of all be determined upon. Because if the court had proceeded to conduct the trial or hear the case, then probably when we eventually get appeal court, and appeal court found that the court not supposed to move on with that matter, without first of all determining the fundamental issues raised before him, then that trial the court conducted will be a nullity. No matter how beautiful it has been conducted, has been done, or the length of evidence or the quality of evidence so far adduced before the lower court. So it simply means powers of the court to hear or adjudicate a particular matter or a subject before him. That's all.
All right. Thank you very much for clearing that out, which means we are dealing with 2 issues here. Number 1 is jurisdictional issue, and number 2 is violation of Nnamdi Kanu fundamental human rights. And these 2 alone is enough to discharge and acquit him. Please go ahead.
Now, you see, let me explain this in further. That was why I actually made effort in posting page 41 as contained in the lead document delivered in the Court of Appeal. When we talk about the start, and also we also have a situation when I talk about acquittal, it's being governed by a different principle of law. If you talk about that, the start can happen when probably someone has got, when the true evidence or probably the proof attached in proof of the charge are not established to face, or where the court has no jurisdiction, like in this case, to proceed with the hearing. The applicant or the person involved can be discharged. Now, there are circumstances under which a person's discharge can also be acquitted. That acquittal can happen where an evidence has been given in proof of the case. Probably when the prosecutor has called one witness to give evidence in proof of the case, then and before the division of the court is challenged. In that case, the court will not stop at discharge. The court can also acquit because evidence has given. But even if the person hasn't been cross-examined, the law says you will discharge him and acquit. But what happened in only in this case is more fortifying, more stronger in terms than acquittal. And now let me say this to you. I will give you a live case. Sometime last 3 months, I was in Ebonyi State to argue our application or no case submission. Some people were arrested, about 13 of them, and accused of being involved in some of the offenses. evidence were led by the prosecution witnesses, exhibits were tendered, and at the conclusion of the prosecution case, we file an objection. We file what they call no case submission, inviting the court to hold that evidence led by the prosecution witnesses are not strong enough to establish the bogus charge preferred against these people. Of course, then you must have seen your television over the social media then. Then the court, at the end of the day, found for us. The court accordingly discharged those 37 persons and acquitted them of the crime allegedly committed in the court judgment. Now, what these people did, on the day the matter was coming up for judgment, obviously they must have had a hint that the judge would discharge and acquit them. Our application having been found meritorious, they went and filed a different charge altogether. Sort of murder, sort of belonging to a lawful society, sort of illegal possession of arms, which is a different charge altogether, which has no connection with earlier charge that they were discharged and acquitted. On the day the judgment was read before the court, and upon the conclusion of the judgment, they were charged with this charge. And now, they quickly picked them up. We are still back to the court. So now, in this Oyendu's case, what happened is more than acquittal. Because assuming without considering to the fact, assuming that the court discharged and acquitted him of these offenses or charge that has been struck out, some people can go and probably develop another charge, and which has no connection with one before the court, and fight against him. Now, so I want to explain to you, for you to understand that what happened in Oyendu's case is more powerful than even as the trial of acquittal. Now, the court in judgment, specifically at page 41, I will read it for everyone to understand and I'll explain it. The court at page 41 holds that the consequence of this section, the court was actually referring to argument under section 15 of the Extradition Act, Cap E25, Laws of the Federation, 204. This was a law ratified and operational in Nigeria. The court was referring to this section and the court holds that the consequence of this section, is that the appellant, that is Oyendu, is prohibited from being detained, tried, or otherwise dealt with in Nigeria for or in respect of any offense allegedly committed by him before his extraordinary rendition to Nigeria. No court thus has no jurisdiction and further hold to try the appellant, that's Oyendu, on count 1, 2, 3, 4, 5, 8, and 15, which were returned by it, being charges allegedly committed by the appellant, that's Oyendu, prior to his extraordinary rendition. In addition, by the possible abduction and extraordinary rendition of the appellant, that's Oyendu, from Kenya to this country on the 27th day of June 2021, in violation of international and state laws, lower court, or indeed any other court. The lower court means the Federal High Court, or indeed any other court in this country, Nigeria, is divested of jurisdiction to entertain charges against the appellant, and I so hold. So this decision is extant. It shows that you can never investigate him again. You can never present any charge against him. You can never file any charge against him. He can never be subjected to any trial whatsoever in any court in Nigeria. So the decision is more powerful than even acquittal on the charge in principle. So that's why they are in dilemma. And they have no option than to obey this decision of the Supreme Appeal. So I believe I've explained it in a manner people will understand. So what happened in his case is more powerful than acquittal at this time. In acquittal, somebody who is acquitted of an offense can still be arrested on a different offense and charged to court. Then in this case, he can never be charged on any offense whatsoever in any court in Nigeria. That's the decision of the court. So go on.
Barrister, so can you explain to me the term? Because the way I see it, it appears that the Attorney General is trying to make something out of nothing. Can you explain that term to me and Biafrans and our listeners? Making something out of nothing, because that's basically what the Nigerian government is trying to do in this matter. Please go ahead.
No, what happened is that placing something, if I can understand you, placing something without, okay, placing something on air.
That's correct. That's correct.
To stand. Now, what it means in effect is that the duties of the courts to defend that matter, to try only before now, before the decision of this court is not there. So the court cannot proceed when there is no jurisdiction. So that's what it means that it cannot place something on nothing and expect it to stand. It must fall. That's that principle. So because it must have powers, it must have jurisdiction to stand. You can't just stand on the air. You must have a ground where you stand. But in this case, the lower court, the federal high court has no ground where you stand. Where you stood before we went to court of appeal. So that's what means that you cannot place something on nothing and expect it to stand. So that is the meaning of things. I hope you understand what I'm saying.
All right. No, brilliant and it's excellent. Okay. Talk to me now the way forward, Barrister. Of course, the law is on our side. What is the way forward? Because as I know, and from what you are saying, the federal government of Nigeria is holding your client, Mazi Nnamdi Kanu, illegally at the moment as we speak now. What is the way forward? Please go ahead.
The way forward is simple. They have practically, as I have demonstrated before now, run out of option. The only option available to them, are you with me?
Yes, go ahead.
Which I've stated before now, is option for them to go to court appeal. If they are convinced that they can succeed, we have no problem. Right of appeal is a constitutional right. Now, they cannot go to court of appeal without obeying the other court.
They have to release him first.
They can't go to Supreme Court without obeying the order made by the court of appeal. So you must pause yourself, because as you speak today now, as I speak to you, Ikechu,
yes,
Onyendu is being illegally and unconstitutionally held in custody of the DSS. There is no court order today sanctioning his further detention from 13th of October. That judgment was delivered to date. So he's now being, in the eyes of law, he's now being illegally held in the custody of DSS. He's not being unconstitutionally held in the custody of SSS. So that's what we are now. And as it stands today, Nigerian government is not incompetent of orders made by the Court of Appeal on 13th of October 2022. Now, and they cannot go to Supreme Court to challenge the judgment of the Court of Appeal without obeying that order. So it cannot be in contempt of court order and be exploring or seeking a suitable remedy for Supreme Court. No. Because he who goes to equity must go with clean hands.
Absolutely.
And we have plethora of authorities that say that when an order is standing, you must obey that order first before coming back to lay a complaint. So that's what we call obey before complain. I will have cases of that, plethora of cases. The same case of action against the federal government. The federal government is still stand. Federal government went to the International Court. However, it was argued. An order was made. International order was made. Directing ASU to call off the industrial action. The ASU went to Court of Appeal to challenge it. The Court of Appeal said, no, there's an order made by the National Industrial Court. You already in contact of this order. Go back and obey the order first and come back. Go and obey this order. Then come back and demonstrate their anger before us. We also have a case of Chief Olufenetu against FRM. Where Supreme Court mandated the federal government to go and obey the order of federal appeal before coming to it. So only in this case will not be an exception. So we have the federal authorities sanctioning the position. So the only option, the only option they have today is to release him unconditionally. Unconditionally. The court didn't say, please release him to Mr. XYZ. No. Or release him to Ikechukwu. Where you are. No. The court and court prohibited foreign detention. In the judgment of this court, the court prohibited foreign detention. The foreign detention where he's being kept now. So everything they are doing today in regards to Nnamdi Kanu's life is tainted with illegality. So, and we're exploring aggressively legal options that will compel immediate obedience. I may not discuss it in this platform, but we are making slow progress. And I can assure you we are seeing green light. Which I may not discuss here. We are seeing green light. You can take that to the bank.
All right. Thank you very much, Barrister. Barrister, I know you're a busy man, and of course, I promised you that I'm not going to keep you for longer. But before I let you go, Barrister, I want you to give some assurance to Biafrans because people are waiting. People, the celebration is on, but somehow it is still on hold and they are waiting for the climax. What assurance will you give to Biafrans that our erudite leader, Nnamdi Kanu, will be with us very soon? Please go ahead.
My brother, it goes without saying. You see, like, how can I explain this? What is playing out now is not unexpected. It's not unexpected. I'll end at that part. It's not unexpected. And because what the autocratic government of Nigeria Spain put in place, the kind of resources they put in place, in effectively and successfully carrying out abduction of Nnamdi Kanu from Kenya is massive. It's monumental. So, but today, they cannot go further than here because law is on our side now. Their own law, they are not the Kenyan law. Their own law. Are you getting what I'm saying?
Right.
Their own law is not on their side. What happened to them today? So what is happening us is their own law. They cannot. It's settled. They cannot go further than this. I can assure Biafrans all over the world. Take it from me. We have done it before. And we're doing it again. We've done it again, actually. So the point is that they should be as assured that Nnamdi will out as soon as possible. But what I know, I will not say. It's the time and the day. But Nnamdi is coming out as quick as possible. And when it comes out, I will carry a bit and let the world know. But just go home and sleep. We are on top of the station. And we are doing everything legally permissible to ensure that the right thing is done. And as I assured you, the Nigerian government has totally run out of options. They have no remedies available to them, legal remedies available to them. And I wish you have a representative of the government of the court. You will see that government is watertight. There's no way you were escaping. There's no way you can escape that government. It's watertight. So that is the position.
All right, Barrister. As you can hear the barrister say, go home and sleep. And of course, if there is anybody who can do it, it is our legal team. They have done it before in 2015, and I don't see any reason why it should not be repeated. Barrister, the last question, Barrister. Now, talk to me about compensation, because we're talking violation of his fundamental human rights. And of course, there should be some sort of compensation that will go with it.
Of course, before now, we have a suit to file against the government for extraordinary rendition of Nnamdi Kanu. In that suit, before compile, we are inviting the court to interpret legal sections of international laws and conventions, which I enumerated before now, which Nigeria has grossly violated in an attempt to abduct and eventually extraordinary rendition of Nnamdi to Nigeria. In that suit, we are asking for damages of 50 billion. And thankfully, interestingly, like it is now, the questions are inviting the lower court, high court to answer. The questions of law, they are inviting the lower court to answer in that suit. has been exhaustively dealt with in this appeal. So what we are doing on 14th of December when the matter is coming up is to submit this appeal, this judgment of court appeal, and ask the court to award them like this as requested. So they must be heavily compensated. Thank you.
Thank you very much, Barrister. And of course, I thank you so much, of course, for making our time coming on air to clear the air for Biafrans. And of course, all the lovers of freedom who has been listening to us. Thank you, Barrister. And of course, we will still celebrate because the big one is still coming. Thank you very much.
Sure.
All right.
God bless you. Thanks.
And bless you too. All right, there you have it, and that was our erudite barrister Ejiofor, breaking it down for us here to a layman perspective so that you can understand what is happening and how it is being played out. But one thing though you need to know, and you need to bear in mind, is that we have won. There is no two ways about it. Nnamdi Kanu always said, I will defeat you at your courts. And that is exactly what played out. And I want to thank our able legal team, of course, led by Barrister Ozokome, and of course, Barrister Aloy, Barrister Ejiofor.